Why don't you let the other side get settled first before you start?
Sure, Your Honor. Your Honor, may it please the court. Indeed, it is my honor to appear in front of you. Thank you for this opportunity. This is a case that concerns contract. It concerns promissory estoppel. It concerns tortious interference. And of course, it concerns fraud in the inducement and fraud by omission. This is a factually intensive case, as I'm sure Your Honor has seen, in terms of the conduct, particularly the contract claim, which deals with an explicit contract. There were two contracts here. One was for a jersey sponsorship agreement with the Houston Rockets, and also an implied contract, which is entitled to the same force and effect as an express contract, except that it arrives over a course of conduct, parties taking certain actions, relying upon each other, giving consideration. The lower court dismissed the case despite Supreme Court precedent under Bell Atlantic versus Twombly that if there's any plausibility to a claim on a 12b6 motion, you can't dismiss the case. There was no discovery in this case, none at all. It was stayed throughout the entire proceeding. Now, getting back to the two contracts that are involved here, one was a sponsorship agreement where my client, we'll call it Rokit, there are three companies, was to have their logo put on the jerseys of the Houston Rockets. That was worth a lot of money in terms of sales. My client sells beverages, they sell alcoholic beverages, they sell other types of beverages. And there were promises made and contractual commitments made that these products would be sold in conjunction with that at the arena there. But as importantly, and even more importantly, because my client paid nearly $10 million up front just for this jersey sponsorship agreement, was the enticement, the sweetener that was provided by the appellees, which is the Fertitta Entertainment and Landry's. They own, Tillman Fertitta is a billionaire. He owns over 600 major restaurants, gambling facilities throughout the United States and the world. And the beverage agreement, which his son, Patrick, entered into to try to negotiate, and he as well, was to showcase the product of my client at all of those establishments, huge amount of potential sales and money. Both agreements are valid. The express contract is valid, and the implied contract is valid. In fact, case law, and I'm sure Your Honor is aware of it, I'm sure you've had many contract cases, it is equal. In other words, an applied contract is just as good as an express contract, and therefore, it falls outside of the statute of frauds, even if the performance was for more than 1 year. But in this case, there's never been a showing that the contract, the beverage contract, couldn't have been performed in less than 1 year. And that's a subject for discovery as well. Yet the court dismissed the case in the entirety of it, essentially on the statute of frauds. Now, here's something that's really important to remember in terms of the implied contract. That's the beverage agreement. Is that based upon representations that we could do sales like you've never seen before at all of these establishments of the alcoholic and other beverages of the Rokit appellees, my client moved forward and invested a lot of money. Invested money in getting distributors. Distributors, by the way, that the appellees wanted us to use. They're distributors. They produced the products. They had to gear up for the products. They had another company, which was to supply all of that, which was the liquor company that came into effect. That was to supply that. They had advertising that they did, and of course, getting ready to meet the demand, they had to hire many employees. Eventually, they had to lay off 27 of those employees when this did not come to fruition. Now, the excuse that's being used by the appellees as to why they couldn't perform on the contract is that the contract was illegal. That's incredible. After the fact, after they intentionally induced my client to enter into contracts, they said, oh, it's illegal. Sorry, we can't do it under alcohol regulations or NBA regulations. Well, they were in a superior position than my client. It was not in pari delicto.
So is Texas law going to allow two parties and you decide which one's more sophisticated and only the more sophisticated one, if it's true, Landry's is that, has to know what the law is?
Well, there is case law to that effect, Your Honor, because...
Only them? Because
that's not...
a little bit of superior knowledge?
That's one aspect of what we're claiming, Your Honor. It's not the primary aspect of what we're claiming. I'm adding that in for good measure. But we should have been advised as to what the intentions were of the Fertitta and Landry's group. And they only raised this argument after we had to bring a lawsuit. It was never raised before. So it's not just that, and this is not the primary aspect of it, but it was the fact that we were induced to get into this relationship. We even created a company, Bogart's LLC, to supply the product that I just referenced before. That we were induced to get into it because the Rockets and the Fertitta Group, which owns the Rockets, wanted us to pump millions of dollars into a sponsorship agreement to have our patches on their jerseys. And what actually they said to us was, put that money into the sponsorship agreement, the jersey sponsorship agreement, but you'll make much more with the beverage agreement, which will pay for the whole thing. So there is a fraud that was committed here, Your Honor, and that is not within the statute of frauds. And, Your Honor, I turn your attention to a case by the Supreme Court of Texas, Formosa Plastics Corporation, United States versus Presidio, 960 Southwest 2nd 41, Supreme Court of Texas, where the facts are very, very similar here.
Let me ask you, and then you can get back to it. Was this in your briefs, this case you're telling us?
This Formosa case? I don't remember whether it is or is not, Your Honor. Okay.
Proceed.
But it is a case that's out there, which I wanted to bring to your attention. And in that case, it was held that fraud in the inducement would not be subject to a statute of frauds. Now, we're claiming either way we are not knocked out by the statute of frauds because we have a valid implied contract here, which is just as good as an express contract. And the contract could have been performed in less than a year. That is subject to discovery. We needed discovery. We need to develop the facts here. But under this case and other cases like it, like the Haas decision, which is in our brief, is that Texas recognizes two measures of direct damages for common law fraud, the out-of-pocket measure and the benefit of the bargain measure. So regardless of any decision by the lower court, which we respectfully maintain was incorrect, they could not take this away from the trier of fact on a 12b6 motion. They had to go to discovery at least. But under that standard, we would be entitled to those damages in any event. And that should go back, as it did in the Formosa case, at a minimum, to get into the issue of damages here. There they ordered to retrial the case, just simply on that issue.
When you say damages, are you speaking narrowly of out-of-pocket expenses? Or are you talking more broadly? Are those the damages you're talking about?
I'm talking both, okay? And here's what the law is in Texas, quoting from Formosa. The out-of-pocket measure computes the difference between the value paid and the value received. My client paid in almost $10 million, got virtually nothing in return, while the benefit of the bargain measure computes the difference between the value as represented and the value received. Now, the value as represented was huge. My client estimated they could have done $400 million worth of sales at these 600 facilities that the Fertitta Entertainment Group owned. It was huge.
Let me talk about the out-of-pocket expenses. There seems to be case law that you have cited, and I think was cited in district court as well, that even if the contract violates the statute of frauds, the affected party, the harmed party, may be entitled to recover out-of-pocket expenses reasonably incurred, whatever all the elements are. I'm just surprised that the Judge Eskridge didn't address that. Was that raised in your briefing in district court, that this is a separate component of damages that might overcome the statute of frauds?
I was not the lawyer at the lower court level, but I believe it was, Your Honor. Besides, we never got to that point because it didn't get past the allegations of the complaint. We weren't there to conduct discovery in court. We never had an opportunity for discovery, and it was out-of-pocket.
Well, there was a motion to dismiss, and the issue is how much of the case needed to be dismissed, and if there's a separate component of Texas law that this part of the case can survive a motion to dismiss of the statute of frauds, it would have been at least something worth mentioning in a brief. So I'm just wondering why Judge Eskridge missed it. If
certainly mentioned it in our brief, and in the Second Amendment complaint, it asks for actual damages, including lost profits, out-of-pocket losses. It's there, Your Honor.
You're talking about your complaint?
Yes, in the complaint.
Yeah, I saw that at the end of your complaint.
Out-of-pocket losses, incidental and consequential damages, treble damages, punitive and exemplary damages, prejudgment interest, award of attorney's fees, and such other relief as the court may deem proper. So yes, we did raise that in the lower court level. And those damages are substantial in and of themselves. They're hiring employees. They're obtaining distributors. By the way, the contract was precise. Parties can negotiate a contract on their own terms. There was no provision for quantity. The lower court got that wrong because under Texas beverage requirements, you could not put a quantity in. The seller of the liquor could not impose that on the retailer, which is why it has to go through distributors. And these distributors were by and large owned by the Fertitta Group, and they knew the pricing. So the pricing was also provided. So you did have not just pricing, but you had showcasing. This was the essence of the deal, to showcase the product in 600 facilities, to have it on the menu, to have customers be able to buy it. And as we set forth in our briefs and even in the complaint, the owner of Fertitta Entertainment and Landry's, Tillman Fertitta, at Maestro's restaurant in Houston's, tested our client's vodka blindly. My client handed it to them, said, which one's better? He said, well, yours is better than Tito's vodka. So this had a tremendous potential to sell, and they were exuberant at the thought of Rokit becoming their partner in these two contracts. But the bottom line is this, and by the way, an implied contract can arise from a number of writings. It doesn't have to be all in a single place. And of course, we cited in the complaint and in the brief some of the writings that shows that there was an implied contract. And just as a matter of logic, you have an express contract that's all in one document, you have an implied contract, it's equal. So even if you went beyond the 1 year, the statute of limitations wouldn't apply because you have two valid contracts. But here, there's no showing that this couldn't have been performed within 1 year because, as you note with the sponsorship agreement, there were payments that were due each year, millions of dollars each year. It wasn't a total payment. It was year by year. So for all of these reasons, Your Honor, is that we have a right to have this case go back in all due respect. We have the right to take discovery. We have the right to develop the facts. It's factually intensive, this case. And the lower court judge could not take it away from the trier of fact based upon Twombly. There certainly is plausibility here. There's more than a scintilla of proof is set forth in the Formosa case and every other case that I'm sure Your Honor confronts. So that's the bottom line. Can I save a minute for rebuttal and add it on to the...
Well, you have 5 minutes for rebuttal.
Right, so I've got a minute.
You don't get to add whatever you have left over here. You get 5
harm in
minutes for
trying,
rebuttal.
right? Okay.
Good try.
Let me sum it all up. Is that you have a sponsorship agreement where our client's paying $9.7 million to lure my client into that. The Fertitta Entertainment Group and Landry says, oh, we'll give you this beverage agreement 2, where we're going to sell it in 600 of our restaurants around the world. We have tremendous reach. We're agreeing to showcase the product. Yours gets showcased above and beyond everyone else, particularly with vodka. And we are also understanding what the price is going to be because we're asking you and requiring you to deal with our distributors. So there were concrete terms. And consequently, there was an implied contract as well as a written contract with regard to the sponsorship agreement implied for the beverage agreement. This would eliminate any statute of frauds issue. But even if you had a statute of frauds issue, just on the basis of the fraud and the inducement in the cases that I cited and the ones we have in our briefs, plus promissory estoppel would jump over the statute of frauds. Tortious interference with Bogart's LLC, and of course, the breach of contract. These are all valid claims that had to be subject to discovery, and this case should not have been cut short by the
All right, Counselor.
Thank you, Your Honor.
May it please the court.
Counsel, Counsel, why don't you stay at the appellant's table, and you'll be available for rebuttal. But it's quite all right.
May it please the court. Elisabeth Butler for the Appellees, Landry's, and Fertitta Entertainment. This argument is just another example of how Rokit's story has been evolving throughout the course of this case. I'd like to begin with the statute of frauds issue. For one thing, Rokit has never stated that this contract could not be performed within 5 years. It's within a year. It's undisputed that this contract had a 5-year term. I would point you to Rokit's brief at page 9. That's been established this entire time. They've never argued before that that's the reason this wouldn't fit within the statute.
Is there a reason to distinguish the beverage contract aspect of this and the sponsorship?
So the beverage agreement and the sponsorship agreement were two separate contracts. That's what they've pleaded the entire time. If these two contracts were tied, that would be illegal under the Texas Alcoholic Beverages Code. So that's why this entire time they've maintained that they're separate agreements.
Why isn't this whole contract illegal under that statute?
So the Texas Alcoholic Beverages Code prohibits the tying of alcohol contracts to other contracts, and there's a specific provision of the Alcoholic Beverages Code. It is 102.07, and that prohibits a alcohol manufacturer from giving anything of value to a retailer. Texas keeps the different tiers of the alcoholic beverages industry separate. So if these two agreements were linked, that would violate that provision. I would also point you to the sponsorship agreement itself, which is in the record. It explicitly states that it's not conditioned on the sale of alcohol. That contract contains a merger clause. So there really is no credible argument that these two agreements were tied. But if they were, that would be an illegal contract that this court could not enforce. Now,
So you say they were not tied?
our position is that they're not tied. Rokit has been inconsistent in their pleadings with whether they are or are not tied. So we just, addressing those arguments, we're saying if we believed that allegation that they were tied, that would be an illegal contract that can't be enforced. Returning to the statute of frauds issue, so the actual issue before the district
Why you're
court.
so timorous about that defense?
Sorry?
I don't understand why you're so timorous about that defense.
Oh,
Seems like it solves the whole case.
I'm happy to address
If
illegality.
this is an illegal contract under Texas law, and the whole thing falls, right?
That's absolutely correct, Judge Dennis. And there's multiple ways that this contract would be illegal. So the tying provision is one of them. If the sponsorship agreement and the beverage agreement are tied, that's
Just to be clear, and I want you to keep answering Judge Ennis's question, but this is something Judge Eskridge did not reach. Is that correct?
correct.
Okay, just want to lay that groundwork, but keep going.
So the tying provision is one way that it would be illegal. Another way that the contract would be illegal that they haven't even contested is the TABC administrative rules. And so these prohibit as an illegal inducement certain practices that put retailer independence at risk. This is 16 Texas Admin Code 45110C. And listed among these practices are that the retailer had a continuing obligation to purchase or otherwise promote the industry member's product, that the practice restricts or hampers the free economic choice of a retailer to decide which products to purchase or the quantity in which to purchase those products, or the retailer has a commitment not to terminate a relationship with a member of the manufacturing or wholesale tier with respect to the purchase of that member's products. So this alleged agreement to showcase what they say promote or sell Rokit Drinks products in Landry's properties violates all of these provisions and would be illegal. And then the third way in which this contract would be illegal is TABC 102.16a, which prohibits an alcoholic beverage manufacturer from entering into an agreement where another person would be required or influenced to purchase a certain volume of or quota of business, more or less, of types of alcohol. And that this doesn't require that there be a specific quantity that's agreed to, but an agreement to buy some quantity of alcohol would violate this provision. And Judge Southwick, I'd like to address your question about whether Landry's knowledge of the illegality would affect this defense. And the answer to that is no. So Texas law doesn't have any kind of exception for if one party knew the contract was illegal and the other didn't.
No sophisticated party component to the issue?
So certainly where there are two sophisticated parties, that's a case where especially the court is not going to enforce any kind of illegality exception. But I mean, there's just not one in general. The only exception is for unequal knowledge of the facts, not unequal knowledge of the law. And I would actually point the court to two cases where this issue has been directly addressed. So Plumlee versus Paddock, it's from the Fort Worth Court of Appeals. It's 832 Southwest 2nd, 757. And then a case from this court, Packard versus OCA, it's 624 F3rd, 726.
Are you also citing to us cases that were not in the...
We did not cite to these cases because this issue wasn't raised until their reply brief. We have cited these cases below in our further reply in support of motion to dismiss, which I believe is at record 488. But these illegality issues, they didn't bring this defense up until their reply brief, so we just didn't have a chance to respond to this. But both of those cases hold that where there are sophisticated entities involved, one can't claim that they didn't know the law, and therefore the illegal agreement should be enforced.
Let's say we don't accept that argument for whatever reason. A lot of times we do things counsel disagree with. So let's say we don't accept it. Let's go back to the statute of frauds. What of the issue, another question I was asking your opponent, of the entitlement under Texas law potentially to out-of-pocket expenses, something Judge Eskridge does not address. Is it raised sufficiently? I do think it is in the damage clause of the complaint. I don't know how much of it's in the text. I didn't look at the briefing. I'm just kind of wondering why it was ignored in the district court decision. That's one question. We can explain why it's ignored, but then I want you obviously to address the law as well as how that plays out.
Sure. So we think it's not really clear that anything that they've pleaded is out-of-pocket damages. Their brief doesn't specify what those out-of-pocket damages would be. To the extent that the court...
So in the explanation of all the things that happen in the complaint, that explanation, there's no statement about the expenses that were being incurred to perform under this contract, under this non-contract, in your view?
There are some kind of vague allegations about steps that they took to pursue this contract, but we think this case doesn't fall into the out-of-pocket damages exception because the damages that they're seeking for fraud are the same as the damages that they're seeking for breach of contract, and the misrepresentations that form the basis of their fraud claim are the same as those that form the basis of the breach of contract claim. So typically in those scenarios, courts have said that those damages would also be barred by the statute of frauds. But again, to the extent that you're hung up on that issue, I would point you to illegality, because there is no such out-of-pocket damages exception. In the illegality context, they haven't pleaded such an exception, and that's because of this larger Texas policy of not enforcing illegal contracts and leaving the parties to illegal contracts where the court found them. But Judge Southwick, to address your question about the statute of frauds. So the real issue was whether there is a signed writing, because again, it's undisputed that this agreement had a 5-year term, so that's going to fall within the statute of frauds unless there is a signed writing. And their pleadings actually affirmatively establish that there is no signed writing. So in their original complaint, they pleaded that the beverage deal could only be a verbal agreement. That's at record 14. And in their second amended complaint, after they removed that allegation, they still include an email from Jonathan Kendrick, who's the CEO of Rokit, and he says, "I know we couldn't put this in the contract, but it was clearly agreed that you would help us get your drinks into our outlets." That's record 217. And once the district court pushed them to identify a signed writing to try to save these claims, the best that they could do was come up with a series of emails. But those emails only reflect a potential deal between the parties. They certainly don't reflect any kind of executed agreement that was ever completed. And they also point to these distributor agreements, but Landry's is not a party to those agreements. There's no allegation that Landry's ever ratified or affirmed those agreements, and they're certainly not signed by Landry's, which would be necessary to comply with the statute of frauds. So for all of those reasons, the statute of frauds bars their breach of contract claim. And as we've discussed, it also bars their fraud claims. And I just wanted to clarify, they did not bring a claim for fraudulent inducement. They brought claims for fraud by nondisclosure and fraudulent misrepresentation. To the extent they brought a claim for fraudulent inducement, they would not be able to recover damages for that, because fraudulent inducement requires proof of a contract, proof that you were fraudulently induced into a contract. And you can look at the Haas case for that proposition. And again, they didn't cite Formosa in their briefing. I know you asked that. And then addressing the promissory estoppel and tortious interference claims. So those go by a similar rule to fraud, but those were not addressed by the Haas case either. So in promissory estoppel, there's only one exception for where the statute of frauds would not bar a claim for promissory estoppel, and that's when there was a promise to sign a written agreement that's been prepared that would itself comply with the statute of frauds. And there's no allegation that that exception applies here. And tortious interference, again, it's a similar rule. The tortious interference claim can't proceed where it relies on proof of an underlying oral promise that would be barred by the statute of frauds. And again, I would say the tortious interference damages also wouldn't even be out-of-pocket damages. Those are really consequential damages about this separate deal that they had with Bogart. Lastly, I'll just briefly address our agreement about indefiniteness. That's another way that the breach of contract claim fails, and Judge Eskridge did rule on that issue. So the promise that they've alleged here is so indefinite and unclear that they can't recover on it. Their allegations with respect to quantity are inconsistent. They say at one point, defendants aren't required to purchase any quantity of Rokit Drinks products under the beverage agreement. But then they also say that defendants promised to buy plaintiffs' products at each of their locations, and defendants failed to order even a fraction of the liquor promised. At another point, they actually say that we're required to purchase Bogart Spirits, so one of the specific brands of their alcohol, at each Landry's location. So, and I would say the damages that they've pleaded clearly hinge on Landry's failure to order a sufficient quantity of their products, but they're never able to identify what that quantity is. And if the plaintiff doesn't even know what the quantity is, that is by definition an indefinite contract. With respect to price, the terms are incomplete. So as we discussed already, they reference the distribution agreements, and they say the distribution agreements can set the price, but Landry's was not a party to any of these agreements. They haven't pleaded that it was. They haven't pleaded Landry's affirmed or ratified or accepted any of these contracts. So Landry's...
What way did Landry Is there some way that Landry compelled Rokit to go to distributors that Landry was used to dealing with?
Their pleading alleges that we requested that they use our preferred distributors. So we have to accept that as true, but that doesn't affect that Landry's would have agreed to these contracts, because Landry's would have to see the price that the distributor ends up setting and then agree to pay that price. And there's no allegation that Landry's did so. So the contract also lacks a price term. So based on these conflicting and incomplete allegations, there's just no way for a court to determine whether or not the contract was complied with. So if the panel has no further questions, I will cede the rest of my time.
All right, counsel, thank you.
Thank you.
Your Honor, the Formosa case is cited in the Haas decision, Haas versus Glasner. Okay, so it was before the court. That's where I found the case that you have, and it's a very important case. And counsel did the best she could. My esteemed counsel, or they say in Great Britain, my learned friend, okay. But she didn't give you all the facts in the complaint. And just looking at paragraph 54, when you're talking about the out-of-pocket disbursements, we listed it with specificity. Paragraph 54, the harm suffered by Rokit drinks was further exacerbated by the numerous actions the companies took in reliance on defendants' promise to order Rokit drinks products of each of the 600-plus locations. The actions that Rokit drinks took in reliance on defendants' promise includes, but is not limited to, 1, increasing production to prepare for the orders expected from Landry's locations nationwide. 2, applying for licensure to sell alcohol in various states where Landry's establishments were located. 3, employing mixologists to craft specialty cocktail menus with Rokit drinks products to sell at Landry's establishments. And by the way, I might mention there's an exchange of all kinds of emails referenced in the complaint which deal with these issues. So it wasn't true what my learned counsel was saying. There was no specificity on these terms, and there were emails about the distributors as well. That just wasn't accurate. 4, employing specific sales staff and management teams to assist with the sales to Landry's locations in each state. So, and there was also another thing, it wasn't mentioned in the complaint, I don't believe, but we actually were asked to change the bottle that we would use for the vodka, for the Bogart's brand. All of these things, Your Honor, should have been subject to discovery. And with the emails that are referenced in the complaint, it's quite detailed as to what, in fact, occurred. Now, it was really a stretch to say that we didn't allege fraud in the inducement simply because the heading on the count says fraud. Yes, it was fraud in the inducement. If you look at the allegations of the complaint, it's fraud in the inducement. You know, the issue of whether or not you could have the beverage agreement incorporated into the sponsorship agreement was not really an issue primarily of the alcohol regulations of Texas, but the NBA itself, okay, which their own regulations don't require. And that's why they did have separate agreements. That's why we have an express contract and a contract that is implied. All of these things are factually intensive issues. And yes, if when Your Honor has an opportunity, Your Honors, and I'm sure you have already, but go back and look at the various cases that are cited, is that all these cases go through an intensive analysis. Just if you look at the Hasner case and you look at the Formosa case, these are long decisions. My hat's off to the Texas Supreme Court. You don't see that in Florida as much, or in D.C., or in other places where I've practiced more over the years. But they really get into the weeds with regard to contract claims. And it is fact-specific. And here, you had a fraudulent inducement and an omission that created a fraud, and they knew they were doing it. So they have to be held accountable at a minimum under promissory estoppel and under tortious interference, and also quantum merit. We provided a lot of value, and we got nothing, little to nothing, in return. So there's a question of equity here with quantum merit in terms of the damage claims. So all we're asking for, Your Honor, is our day in court. And I might add that this contract was specific. It was to showcase the product in 600 Landry's facilities. It was to do it in a way that consumers, people who frequented those restaurants, would see it and buy it. It was to be on menus. That's in the email exchanges. This was promoted by the appellees. You know, give us the $10 million to start off and millions every year, year by year, on the sponsorship agreement, and we're going to make sure you sell a lot of product in our facilities, and that'll more than cover what it's going to cost you for the jersey sponsorship. And there are emails to that effect from Patrick Fertitta, the son of Tillman Fertitta, and others that were representing the appellees. And those are in the complaint, and the lower court had access to that. And last but not least, we could not put quantity in there because the manufacturer cannot dictate under Texas alcohol regulations that a certain quantity be sold by the retailer. So to say that the contract is deficient because of that is disingenuous, Your Honor.
All right, counsel.
Thank you, Your Honor. We'd ask that this be reversed, remanded to the court with instructions to allow for discovery. Thank you.
We'll take the case under advisement. Appreciate your assistance, both of you.